Golden Strait Corporation v. Nippon Yusen Kubishka Kaisha, The Golden Victory, 2007. The claimant sought damages for repudiation of a charter party. The charterpary had been intended to continue until 2005. The charterer repudiated the contract and that repudiation was accepted, but before the arbitrator could set his award, the Iraq War broke out, under which the charterer could have terminated the charter as of right. The defendant asked that the damages be reduced even though this event occurred after the repudiation. Awards of damages for breach of contract are compensatory. The damages were to be assessed to make allowance for events after the repudiation which reduced them. Lord Bingham, dissenting, said that the later events should not be taken account of. Contracts are made to be performed, not broken. It may prove disadvantageous to break a contract instead of performing it. On their repudiation being accepted, the charterers had promptly honored their secondary obligation to pay damages. The transaction would have been settled well before the Second Gulf War became a reality, and the owners were, as the arbitrator held, entitled to be compensated for the value of what they had lost on the date it was lost, and it could not be doubted that what the owners lost at that date was a charter party with slightly less than 4 years to run. Lord Walker agreed. Lord Scott of Foscote dismissed the owner's appeal and said, "The assessment at the date of breach rule is particularly apt to cater for cases where a contract for the sale of goods in respect of which there is a market has been repudiated. The loss caused by the breach to the seller or the buyer, as the case may be, can be measured by the difference between the contract price and the market price at the time of the breach. The seller can resell his goods in the market. The buyer can buy substitute goods in the market. Thereby the loss caused by the breach can be fixed, but where the contract for sale of goods is not simply a contract for a one-off sale, but is a contract for the supply of goods over some specified period, the application of the general rule may not be in the least department. Certainty is a desideratum and a very important one, particularly in commercial contracts. But it is not a principle and must give way to principle. Otherwise, incoherence of principle is the likely result. The achievement of certainty in relation to commercial contracts depends, I would suggest, on firm and settled principles of the law of contract rather than on the tailoring of principle in order to frustrate tactics of delay to which many litigants in many areas of litigation are wont to resort. Lord Carswell said that considerations of certainty and finality have in this case to yield to the greater importance of achieving an accurate assessment of the damages based on the loss actually incurred. Laud Brown of Eton under Haywood said, "The breach date rule does not require contingencies such as the likely effect of a suspensive condition to be judged prior to the date when damages finally come to be assessed, and the owner's argument here seeks to extend the effect of the available market rule well beyond its proper scope and to do so, moreover, at the plain expense of Lord Blackburn's fundamental principle, to restore the injured party to the same position he would have been in but for the breach, not substantially to improve upon it." It is one thing to say that the injured party, mitigating his loss as the breach date rule requires him to do, thereby takes any future market movement out of the equation and to that extent crystallizes the measure of his loss. It is quite another to say, as the owners do here, that it requires the arbitrator or court when finally determining the damages to ignore subsequent events, save where the defendants can demonstrate that at the date of breach some suspensive condition would inevitably and immediately have operated to cancel the contract. There is no warrant for giving the rule so extended an application.